right, you are Robert Isaiah Paredes?
Yes, ma'am.
And Mr. Paredes is on probation in cause numbers 16-24053, that one for prohibited weapon possession, 20-35328 for aggravated assault causing serious bodily injury, and 20-35329, also aggravated assault causing serious bodily injury. Was in court previously, entered pleas of true to counts 1, 2, 3, and 6. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
Nothing with that.
Any testimony with regard to any of the other allegations? Mr. Smith?
Judge, we have each person here for.
I'm sorry, I can't hear you.
We had the probation officer here, if you'd like to hear from him. I believe that, yes, I did address.
I mean, I have what he put in here, but I just am asking if there's any witness, if you want to put in on any testimony for the counts that were not pled true to or not.
It's up to you.
I would ask him a few questions if the state's not going to call him.
So I guess we will do.
All right, Mr. Patton, if you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead.
Mr. Paredes was ordered to perform community service, and has he completed all of that and provided verification to the probation department?
He is not, no.
And did he appear for alcohol or drug screening on June 18th, June 25th, July 2nd, July 5th, July 21st, 2025?
What were those dates again?
June 18th, June 25th, July 2nd, July 5th, July 21st, 2025.
So June the 18th, he did not show. June the 25th, he did not show. July 5th, he did not show. And July 21st, he did not show.
That's what it's.
I guess I want to know with regard to community service, obviously what has he done out of any of it, if any?
Your Honor, in cause number 16-24053, he has completed 169 hours out of the originally assessed 300,
Okay.
which leaves him with 131. He last performed community service on April 4th of this year. He worked with our work crew at my Beaumont office. He has not performed any of the community service in either of the other two cause numbers.
Okay, thank you. Mr. Kimler?
Shouldn't the community service be concurrent in all three of the cases? In other words, the community service that he's done in one case should transfer and be credited against community service required in the other cases?
It is, yes, you're correct.
So he would have 169 hours in each of the three cases
Yes.
credited, is that right?
Yes.
And is that so even though he was already on probation on one and then we gave him probation on two after that?
It is typically how we do that, Your Honor. We typically will give them credit for community supervision on any of the cases they're doing for us, regardless of when they started supervision.
Community service.
Yes. Sorry.
May I proceed, John?
Yeah.
How long have you supervised, Mr. Patton?
So I'm a unit supervisor at our department. I've seen Mr. Paredes on numerous occasions for administrative hearings, case staffings, and when I've held down a caseload when we've been in between officers.
But you have some familiarity with him?
I do, yes, sir.
And during the times that you supervise him directly, has he maintained proper demeanor with him?
Yes, sir. Yes.
Proper decorum, all those things?
That is correct, yes, sir.
And should he be continuing on probation, you would not be the supervising officer, that would be someone else, is that right?
That is correct. I would not be supervising him.
Well, let's say, I suppose you acted as a supervising officer at some point in your career at the probation department, is that right?
That is correct, yes, sir.
Assuming, let's just speak hypothetically, if you were a supervising officer again, would there be anything about Mr. Paredes that would cause concern to continue to supervise him as far as his demeanor and decorum and attitude towards the probation department or personnel?
Hypothetically, no, not concerning those items.
Who was his supervising officer?
His supervising officer was Alexandra Ariano. Ms. Ariano went out on maternity leave and elected to stay home with her child. And so we've since filled that vacancy with a new officer.
But she was the one that was, I guess, directly supervising.
That is correct, yes, sir.
You have access to her records, is that right?
I do, yes, sir.
Is there any indications in there about some type of mental health referral, anything of that nature?
No, sir, there's not. Not that I've come across.
And nothing in the records that indicate that there's ever been any type of mental health assessment or mental health recommendation for Mr. Paredes, particularly not for schizophrenia or anything like that, but perhaps depression or...
Not that I've come across, no, sir.
That's what it is.
No further questions.
All right. So, Mr. Paredes, it shows here in this updated pre-sentence report that one of the things you told Mr. Patton was that you had been on probation since you were 18 and you just couldn't do it anymore.
Yes, ma'am.
That's true. And then you said, I'll take a safe P. I feel like prison's going to make me worse and blah, 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 but I feel safe P is the best thing for you. So tell me what you're asking for and tell me why.
Well, at the time when I told him that I couldn't take probation anymore, that was one of the times where I was just feeling real down and depressed, from everything that's going on in the past, with me being shot and stuff like that. I was shot in my neck and my arm, so since then I've been having real bad PTSD, real bad depression, bipolarness. So, there's some days where I'm good, some days I'm not, some days I wake up on the wrong side of the bed from having nightmares, and some days I'm just as happy as I can be. So from that point on, at this point, I know since being in jail now, this isn't what I want because it's just hurting my family, hurting my daughter, and being around the people that's around me, being around murderers and rapists and aggravated robberies and all that. It's just a bad environment for me, and it puts me in a bad mood. Puts me, in a bad mindset, I guess you can say. And I did speak with the counselor I had that they assigned me for probation, and I did tell her those things, and they did recommend MH&R, but I never went just because I felt like it was I felt kind of low, of thinking I would go to MH&R, because
Stigmatized.
yes sir. So at this point, I don't want to go to jail or prison. Feel like being in here, sitting in here, has helped me realize that my life is on the line and it isn't a game and it isn't a joke. And but I do need help mentally. I was prescribed Zoloft the last time I was in here due to my PTSD, but I never took it. Because I heard really bad things about it. But now I'm starting to realize maybe I should be on Zoloft just to control the urge of smoking weed and that kind of behavior.
I could ask him a few questions, Ron.
Sure.
I'm
Wait,
sorry, Ron.
best you can, raise your right hand. Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Explain those facial tattoos to the judge.
This tattoo right here is my daughter's birthday, 11/14/2017, and this is 9/16/22 is the day my cousin killed himself. He shot himself in the head. This was right after my uncle had passed of cancer, and my cousin who just passed away, his dad, my other uncle, had just passed due to cancer as well. That's why I turned myself in a week later after my warrant had came out. This tattoo on here is a heart and a music note. I got that for my ex-girlfriend, being dumb at the time.
No gang affiliation.
No gang affiliated tattoos on me.
And you did turn yourself in on the warrant?
Yes, sir. I did turn myself in.
How are you maintaining employment when you're out?
I always held a job. Always held a job, even if it's working at Whataburger.
What was your last job?
Shipley's Donuts was my last job to maintain, because I got laid off. I was with Bechtel. I was a carpenter for Bechtel for about 1.5 years.
At the LNG plant?
Yes, sir.
LNG terminal?
Yes, sir.
What were you out? You were a carpenter?
Yes, sir.
Scaffold builder? What were you?
We were doing woodwork, building decks and
Okay.
carports and lunch tents and that nature.
And as far as being shot, that actually, I know the court, in looking at his criminal history, these are serious cases as far as the aggravated assault, serious bodily injury. You were actually shot during that interchange, is that
Yes,
right,
sir.
by the other people?
Yes, sir.
And you had returned fire?
Yes, sir.
That's not
I
what,
understand, Your Honor, but it's not, I don't want the court to think, I'm just looking at it, and I'm not trying
my
to.
understanding from the version in the pre-sentence report previously, and
I didn't represent him.
my recollection of it actually, because it's not good when I remember you. The fact that you were already on probation for a felony,
Right.
and then you came in and you admitted that you went there to shoot, you went there to go shoot Christy, but, which is your child's mother, right? That's not true? No? So did you mean to go shoot the two girls that got shot, Alexis and Taylor?
No, ma'am.
Who'd you mean to shoot?
I didn't go there to shoot anybody.
I think as he explained it to me, he was going there to meet for sexual purposes, the two girls, and when he got there, he was set up in the parking lot, and then by other people there, by people who were gonna rob him, and in the course of that, there was a gunfight, but he wasn't going there to shoot anybody.
All right, well, that's,
He was going there for an illegal purpose,
that goes against everything that was said and everything that he agreed to back then, because,
That's correct, Judge. We were getting ready for trial on this case.
Yes.
He was the aggressor. He was the one that fired first, and had he been a better shot, Alexis and or Taylor might have been killed, but he was there to go kill Christy.
I didn't represent him on
okay,
that, so I don't
all
know.
right. Anything else? All right, Mr. Smith, argument?
Judge, I would agree with the probation that I believe he's only asking for safety now simply because it's the only alternative he sees to prison. I don't think he's sincere about it. We have given him chance after chance after chance, and he has squandered, wasted, and even though he's a nice guy when he shows up, he does what he wants to do. That's evidenced by the jail reports that shows that they tell him to go back to his bunk and he just gets in the shower with his jumper on. And then when they write him up about it, then he says, man, fuck you. He has zero respect for authority or doing what's right, what he's supposed to do. I think prison term is appropriate in this case. The PTSD excuse is weak. He was the aggressor in the initial contact. And you can't claim that, well, I feel bad because I got shot by somebody who was defending two other women. So I would ask for pen time in this case.
Anything else, Mr. Kimler?
Well, it's difficult for me to address always with these jail incident reports without having the opportunity to cross-examine the person that made the allegations. So I would ask the court to consider the fact that that's not subject to, those allegations aren't subject to the rigors of cross-examination. But I think that on Mr. Brady's behalf, struggling with depression is a serious matter, and I know, and I respect Mr. Smith's looking at this as a way somebody just volitionally, or somebody just deciding to be stubborn and self-centered and not complying, but depression is a serious problem. He has struggled with that. I think that's indicated by the limited mental history that we have. There is no new offense allegations in this. These are administrative violations. Of course, those are important, especially reporting. But because of the seriousness of these cases, I would ask that the court give him at least one more chance with the aid of mental health, maybe safety, but also as a follow-up if he gets out, to follow up with Spindletop, to address not only any substance abuse problems, but any underlying mental health issues that may contribute to the substance abuse and just his ability to comply and just to continue on probation.
All right, thank you, Mr. Kimler. So, Mr. Paredes, the thing is, you've been given exactly what Mr. Kimler is asking for. You've already been given that. You said it yourself. They recommended Spindletop. They recommended medications. You made conscious decisions not to follow through with what they knew was best for you, which is part of your probation. Everything that they say you should do is a court order. The fact that you are on a probation for possession of a prohibited weapon, like you said, from back when you were 18 years old, put you on a probation, 10-year deferred for that, November of 2016. Then we're back here, you're put on probation for 10 deferred on 2 aggravated assault causing serious bodily injuries in March of 2022 for shooting 2 girls. And you got shot in self-defense. And it appears that there's no real reason for me not to believe that that's how it happened for a number of reasons. No one else was charged with aggravated assault for shooting you. All the police reports, everything that went through in those pre-sentence reports previously that I have copies of, all makes it appear to be true that you went there to shoot either Christy and or whoever else. And luckily were not a good shot. One of the girls got shot 3 times and survived it. And for you to say you have PTSD from getting shot, I can't imagine what she has. I feel like you've been given every opportunity. And when I look back on some of these times where I give chances like I gave you, it's very frustrating and a little embarrassing because it looks like I was not really thinking clearly then. I understand that these are drug allegations. You've been getting opportunities to get help. I mean, you've been on probation since 2016 with every opportunity possible. So at this time, in cause number 16-24053, I'm going to, also based on the evidence presented today, I am going to find count 5 true. So that makes you pled true to counts 1, 2, 3, and 6. I'm finding count 5 true based on that evidence in each of the cases. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 20-35329, also find counts 1, 2, 3, and 6 that you pled true to those freely and voluntarily. Find them true. Also find count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in that case. In cause number 20-35328, again, find that you pled true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true. Make a finding of count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will also be an affirmative finding of a deadly weapon in that case. All 3 of these will run concurrently, which means together at the same time. I am going to hand you a trial court certification. These were not agreements. You do have some rights to appeal. You can talk to Mr. Kimler about that. I need you both to sign and fill out the bottom, and you'll get a copy. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right. I'm sorry?
It was 7,
12 and 12.
12.
Affirmative finding of deadly weapon on both of this. Good morning, you're Nathan Lamel, Senior. And Mr. Lamel was previously in court and entered a plea of true to count 1 in a motion to revoke deferred probation. On probation for evading arrest or detention with the use of a vehicle. And that was from February 17th of 2025. Count 1 that he pled to was the count where he was arrested for a burglary of a habitation. It was not necessarily that he had committed it, but that he had been arrested for it.
And Judge,
And, go
just,
ahead.
so you're aware, the motion reads kind of funny that you pointed out to us last time. So I could technically abandon 1 and 2. I just kept them there for your review, have corrected them in 7 and 8, I believe.
Okay, so
That's
there
why
was a
it's
first amended.
Yes, ma'am.
So we need to go through that first amended.
Correct. And then Ms. Branch will be here to testify in place of Ms. Jefferson if those please don't change.
Okay, hold on a second. Let me pull this up correctly. So let's go through that motion. Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. And will he waive the formal reading of the first amended motion to revoke unadjudicated probation?
So,
So again, and this is 24 DCCR 0826. You have a first amended motion to revoke your unadjudicated probation. Shows you were placed on probation February 17th of 2025 for evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? It alleges you violated your probation, and I'm going to go through the whole thing again, just because I don't have the other one right in front of me. It'll be easier. So count 1 alleges that you were arrested. Okay, so did you want to,
Abandon 1 and 2, Judge, and show that they're correctly reflected in the First Amendment 7 and 8 committed.
all right,
That's
so,
what you didn't like the arrested for last time?
well, I mean, arrested for is fine, but it's not a violation
Correct.
of your probation.
Correct.
Okay, so 1 and 2 will be abandoned. So count 3 alleges that you failed to report as directed to the probation department March 5th and April 9th of 2025. And is that true or not true? True or not true?
true or not?
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true? That's marijuana, THC. Count 5 alleges that you were at a location other than your residence at approximately 3:01 a.m. April 26th of 2025 in violation of your probation. Is that true or not true? Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that on May 1st of 2025, you tested positive for alcohol. And is that true or not true?
That's true.
Count 7 alleges that you committed the offense of burglary of a habitation April 26th of 2025. And is that true or not true?
That's true.
And count 8 alleges that you failed to avoid injurious or vicious habits and refrain from behavior harmful to others, and that you were aggressive towards both Beaumont police officers and the complainant, Aronia Parkerson, on or about April 26th of 2025. And is that true or not true?
That's true.
Count 9 alleges that you provided a urine sample May 1st of 2025 that tested positive for ecstasy. And is that true or not true?
Your Honor, if I might, I don't think ecstasy is listed in the Controlled Substances Act. It would be MDMA. That's the rich street vernacular for methylene dioxymethamphetamine.
Okay, so if it's the same thing and it's just another name for it.
But I'm not sure that would be a violation. What would be characterized as ecstasy? If they want to amend to allege MDMA, that would,
Ms. Malfino?
I'll make that oral amendment, Judge, to change ecstasy to reflect MDMA as worded in the Controlled Substance Act.
All right, so any objection to that?
no objection.
All right, so that count 9 alleges now that you provided a urine sample that tested positive for MDMA, which is also ecstasy. Is that true or not true? Did you enter your pleas of true to counts 3, 4, 5, 6, and 9 freely and voluntarily?
Yes, ma'am.
And because they're actually true.
Yes, ma'am.
All right, so with regard to the burglary of a habitation, Ms. Malfino, what is the state's position as far as wanting to, do you want some time to
Judge,
prove that, or?
I will defer to whatever the court would like me to do. The complainant in that case has filed a non-prosecution affidavit and has also indicated to my office that she does not wish to cooperate in that case.
Okay.
I do believe Ms. Branch can testify with respect to that injurious or vicious habits in her reflection or read of the police report if Mr. Kimler wouldn't object. Otherwise, if you would like me to get those officers to detail his behavior on that night, I can do that, but she has not been cooperative with me.
Okay.
Obviously, Your Honor, I would like the opportunity to cross-examine if the state does attempt to prove that up. I would just observe that whatever conduct Mr. Lamel did engage in didn't result in criminal charges being filed to the level of resisting or harassment or anything of that nature, retaliation.
So we already did the updated pre-sentence report, And the recommendation in that report, it was unagreed, and the recommendation at that time was that he would benefit from both tracks of ISF. Can't do both tracks, but so go in and do the substance abuse track, followed by JCDI, anger management. Ms. Malfino, since it can't go if the other case is pending, I guess based on what you're telling me about the complainant in the other case, what is your position on that?
To not proceed on that case, Judge.
Okay, so there'll be a dismissal.
If we order him to ISF, I will file a dismissal today so that doesn't hold him up. If that's also Ms. Branch's.
Is that still your position?
Yes, ma'am.
Cognitive track or substance abuse, you know?
Well, substance abuse is clearly an issue. I think I would rather do substance abuse and then JCDI and then whatever other behavioral thinking,
You mentioned.
moral recognition or something like that once he's out, and so that we get the more intensive substance abuse before he gets out for JCDI would be my thought. What do you, or would you think cognitive track would be better? You do? Okay. So what is the status of the relationship with the complainant? What's her name?
Ronia.
I'll represent to the court.
Aronia Parkerson. I'm asking him. I'm asking
I
him.
understand that she's present outside the court.
Okay.
wants to speak with us.
So what is your status of your relationship? Are y'all still together?
He is no.
Do you want to ask her some questions since she's here?
Maybe so, Judge, if I may. I didn't realize she was.
You want to go visit with her for a minute, or do you
She's
want to have her
outside.
brought in?
Oh, we can just have her brought in.
Would you please call the name Aronia Parkerson?
So, drug substance abuse.
If you'll scoot over just a little bit towards your attorney. Ma'am, come right over here. You just come on up right here. Would you please state your name, please?
Ariana Parkinson.
And Ms. Parkerson, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Ms. Malfino?
Thank you. Ms. Parkerson, can you please describe for the court the nature of your relationship with the defendant, Nathan Lamau?
He's my boyfriend.
And is the gentleman in the orange to your left, is that Nathan Lamau?
Yes, ma'am.
Your may the record reflect that the witness has identified the defendant in this hearing.
The record will so reflect.
Judge, on Saturday, April 26th of this year, at approximately 6:15 in the morning, were officers of Beaumont Police Department dispatched to your home in reference to a burglary call that had been made.
Yes, ma'am.
Can you tell the court about that?
Me and Nathan had got into a disagreement. I really don't recall what the disagreement was about, but, the first time they were called, he was trespassed. And the officers explained to me that if I called them back, that the trespass warrant would be voided. I was okay with that because I knew I was gonna call him back eventually. But he came back a second time, which made me call them again because he wanted to talk about whatever we had a disagreement about, but I didn't want to at that moment. I was going through a lot. I had just had my son a month prior, so I was dealing with postpartum. And at that moment, I just didn't care to hear what he had to say. But he knew I called the police back, but my dad was also at my house, and my dad wanted to talk to us both to see what the problem was between us, which is why he stayed, and he was arrested that night.
At approximately 5 a.m. that morning, or thereabouts, 5:20, were you awake and on the sofa in your living room, I'm sure probably with your new baby?
Yes, ma'am.
And what did you hear going on in your bedroom? Breaking of glass, rustling of things around?
Yes, ma'am.
And tell the court about that. What is it that you observed? Did you observe the defendant coming forcibly into the window of that residence?
I wouldn't say forcibly.
Had you given him permission?
No, but I heard him trying to open the window, and at that point, I started recording a video just to get him away. once the police was brought back.
Did you feel like that entry into your home was with the intent to possibly assault you based on what had been happening previously that evening and with respect to the nature of y'all's ongoing relationship?
No, ma'am, I don't feel that I was in any harm. He just wanted to talk.
So you don't believe that it was his intention to assault you, or that he could have possibly assaulted you in that scenario there?
No, ma'am.
But you
Like,
still felt it necessary to contact the police on multiple occasions that night?
I just wanted him to leave. I didn't want to continue to talk about the situation. If he would have left the first time and then came back the next day, we could have revisited our situation. Just like when he was released 3 days afterwards, I think accusation is what it's called. He came back to my home and we talked about the situation, and moving forward, we've been good ever since.
Okay. Is that baby his?
Yes, ma'am.
Okay, and is it true that on May 10th of 2025, on August 7th of 2025, that you came in and gave a non-prosecution affidavit signed with Investigator Troy Robinson of my office, indicating that you did not wish to pursue the burglary charges against Mr. Lavelle?
Yes, ma'am.
And is that what you're telling Judge West here this morning?
Yes, ma'am.
This is the turning point of the hearing. Judge West focuses on a critical issue. The defendant had already been given access to treatment programs, mental health recommendations, and opportunities to succeed while on probation. The judge explains that these were not optional suggestions, they were court order requirements. While the defense argues that mental health struggles and PTSD played a role in his behavior, the court must also consider accountability and compliance with probation conditions. Judge West acknowledges the seriousness of what happened, including the previous aggravated assault cases, and questions whether continuing to offer more chances will actually lead to change. The courtroom now faces a difficult balance between giving someone support and holding them responsible for repeated failures. Do you think another opportunity was the right choice, or had the defendant already used too many chances?
How do you feel when you hear out loud what you did that night?
Really disappointed.
Not good for your baby, not good role model, not good for the relationship, and not good to keep you out of jail or prison, right?
Right.
So what I'll do then, based on that and based on her representations and probation's willingness to try to help you so that you can be successful, is I'm going to find that you entered your pleas of truth to counts 3, 4, 5, 6, and 9 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to follow this agreement, or not agreement, I'm going to follow the recommendation, and I'm going to continue you on probation. I am going to extend your probation for 1 year. I'm going to order that you enter and successfully complete the substance abuse track of the ISF program. And then when you're released, your aftercare will be through the JCDI program. You will also be required to follow any other new recommendations or classes with regard to making better decisions, cognitive thinking, things like that. This is all meant to help you be successful. I want to make sure you understand, though, that if you come back here again on another motion to revoke, you're probably not going to get the same. I'm sorry?
I'm sorry, I
Yeah, no, you're not going to get all of this again. Does that make sense? You're likely going to be going to prison, and you could go to prison for up to 10 years. You could do that today. I could send you to prison for 10 years just for the violations you've already had that you agreed to, the testing positive and all that. I don't need a new case. I don't need any of that. I can send you to prison today. I don't want to do that. I want you guys to work things out, but you've got to make things where that works in a very productive and nonviolent and non-confrontational, sober way. Okay? So, probation will let you know what all, again, that you need to do, but you'll go from here to ISF. Once you get out, you'll be in JCDI. No violations. Okay? All right. Good luck to you, sir.
Just before we begin, I'll let you know what we've proposed to see.
Okay.
If you even go any further or not.
Okay.
We were here a couple weeks ago on Mr. Byerly. It's my understanding I had previously prepared for a hearing on those new offenses. At that time, the case was reset, so I did not have the officer subpoenaed for today, I can certainly get them if the court would like to hear from those. It's my understanding that he now intends to enter pleas of true to those new offenses. When we were here last, we had made the suggestion of ISF/safety. It came to my understanding that he's already gone to ISF, just from the reaction that the court kind of gave us to that, and in my extensive conversation with Ms. Johnson, we have taken that offer off the table and made an offer of 5 years in all 3 of the felony cases for a revocation, which would then make him a repeat offender if he's back in front of you.
Okay. And that's your understanding and your agreement as well, Mr. Burbank?
Yes, Your Honor, and we prepared paperwork and 3 indicated 2 MTRPs and new possession.
I only see 2. Is there another set of paperwork? I've got the 2 MTRPs. I don't
And
see the
there's
new
also
case.
possession that I sent.
So we already went through those motions. I guess I just need to go through them again because there's going to be a change of plea.
3, 4, and 6, Your Honor.
Let me, if you'll print the second one, I'll print the first one. Let me get those pulled up real quick just to make it easier for me to go through. And we can print the ones that were already modified. That way I can make notations on that.
And Judge, just again, I know I had let you know last time, I'm not meaning to interrupt you.
Go ahead,
While you're
just
reading,
print.
obviously the concern of the original underlying offenses back in 2017 that carried on until 19 was the violation of protective order. I've continued to maintain contact with that family and can assure the court that they have assured me that there has been no issue with Mr. Byerly.
Good.
So
Thank you for
I just
that
want
as
the
well.
record to reflect that.
Okay. I'm getting there. Okay, so,
Would it be better if I made an oral motion to withdraw previous?
nope, I'm just gonna go back and, I'm gonna just rescind everything that we did at the previous hearing, and that way we start fresh from this hearing, and there's no mistake on what everyone's agreement is and what he's pleading true to, and we'll do all of that today. So will he waive the formal reading of the motion and the indictment?
Be well and
The motions.
all cases.
Okay. Mr. Byerly, in cause number 18-28800, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation May 13th of 2019 for the offense of violation of a protective order. That's a 3rd-degree felony, and that was a 10-year deferred probation. Is that correct?
Correct.
And then in cause number 18-29063, I also have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, also for violation of a protective order, a 3rd-degree felony, and that was also a 10-year deferred probation. Is that also correct? And so it alleges that you violated your probation, and y'all are going to go,
1, 2, 3, 4, and 6.
okay. The new offense that he's about to plead is the possession, right?
Correct, that should be number 6.
That's 5.
Oh,
6 is that he possessed it. I mean, but 5 is committed the offense. So that would make
I'm
sense.
sorry, they're different numbers in each one.
Oh,
One is 6 and
great.
one is 5.
I love that when that happens.
If you want to amend, Judge, we'll go.
No, it's okay. I have to do, it's the numbers are the numbers. Okay. Count 1 in each of these cases alleges that you violated your probation by committing the offense of assault April 21st of 2025. And is that true or not true?
True.
And then count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates in each case. Is that true or not true?
True.
2. And then count 3 alleges that you failed to provide verification of attending the JCDI program. Is that true or not true?
True.
And that's in each case as well. Count 4 in each case alleges that you failed to abstain from the use of any and all intoxicating substances and that you tested positive for alcohol April 15th of 2025. Is that true or not true?
True.
And that's also in both cases. Count 5 in cause number 18-29063 and count 6 in cause number 18-28800 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true?
True.
Is that enough for everybody?
Yes, Judge.
Sorry. I feel like I've gotten through it without messing up, but if I keep going on the different numbers. All right. Did you enter your pleas of true in each of those cases freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
In both of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
I understand.
State tenders number 1 in each of those cases.
No objection, it's one.
It's admitted in each of those cases. Is there any evidence that Mr. Byerly is not competent?
Not even-
All right, Mr. Byerly, in each of those motion to revoke your unadjudicated probation cases, I am going to find that you entered your pleas of true freely and voluntarily. And cause number 18-29063, find counts 1, 2, 3, 4, and 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 18-28800, find counts 1, 2, 3, 4, and 6 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Bless you. Give me just a second now. Those 2, and did I print 2?
Yes, ma'am.
Okay, now let's go to okay. Now, Mr. Byerly, in cause number 25 DCCR 0943, you're charged by indictment with a third-degree felony offense of possession of a controlled substance from May 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In that case, I also have here on the computer some documents that have your signature on them. Did you go over these also with Mr. Burbank?
Yes, ma'am.
And do you fully understand them? And you understand if I follow this agreement, you will also be waiving or giving up any right to appeal.
Yes.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tender's number one in that case. It's admitted. Mr. Byerly, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will all run concurrently, which means together at the same time. I have handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify.
Judge West ultimately delivers the final decision after hearing both sides of the argument. The court finds the probation violations true and sentences the defendant after determining that previous opportunities, including treatment recommendations and probation support, were not successfully followed. The defendant receives prison sentences for the prohibited weapon possession case and the aggravated assault causing serious bodily injury cases,